A snowstorm shuts down an entire state, and suddenly, justice itself freezes in place. Defendants wait helplessly as flights cancel and courts scramble to adjust. But when one lawyer dares to challenge fate, the courtroom tension starts to rise.
Okay, so tell me what's going on.
Dave's asking for extension.
So this one for Sims, we're asking for an extension from Mississippi for a probation violation for malicious mischief. Obviously, due to Winter Storm Enzo, they're requesting extension because the airports were literally closed.
Get ready. We're going to get so many of these, you know?
Oh.
Let's get ready.
Yeah, they're
There's-
coming.
And so this one, they're requesting out to the 27th. Or sorry, the 28th. They'll pick up on the 27th. But because even with when they were originally supposed to come on the 21st, it wrapped around the weekend. That's why we're entering the pre-signed waiver. Ricardo is opposed, which is why I'm entering it.
Okay, I mean, I have to, circumstances beyond, act of God, right? As they say.
Of course, I gotta be opposed. I gotta fight for my client. His expectation was to get out at a certain day, through no fault of his own. He's gotta be here an extra 7 days, looks like. He doesn't control the weather. Nobody does.
Is it 7?
It's well, because the original pickup date was the 21st. Well, so yes, the 21st, and then the court reset date would be the 28th. They're looking to pick them up on the 27th.
Just get it a little bit less than a week. Understand that there is an act of God, right? That just completely close everything. You get just one kernel of snow, the entire city shuts down. So I'm going to grant them an extension. You're not going to get another one.
I have to ask Judge.
So understand, Mr. Kim, that I don't,
They had like 13 days before the snow. That's what I'm saying. Why didn't they come in?
well, I can't answer that. I mean, that's something.
Oh, yeah.
Judge, I would ask, would you consider giving him a bond so he could go turn himself in and not have to wait 7 days? That's what we.
For the pre-signed
It's
waiver.
a pre-signed waiver. I
Pre-signed
can't
waiver,
get
he's
them
not
all.
allowed.
Understood.
Yeah, I mean, you got to understand when you get on probation or when you get on parole in another state, you sign conditions. One of those conditions is that if you ever take off and you become a fugitive, you waive extradition. It's a pre-signed waiver. You have already waived by virtue of signing. You need to read every single thing that when you sign it, all the little print, because even if I wanted to give you a bond, I can't because you have already waived by signing that document.
If for some reason they don't make it by this deadline, will he be getting out?
That's a great question. Mr. Kim?
Unfortunately, with the full, I got to look at the original waiver date. So it's 5th. So statutorily, they have until February 4th, 2025. So strictly speaking, for the pre-signed waiver, he's not allowed to. But this is one where they've already confirmed they're coming on the 27th. So I think it will be a distinction without a difference because they've already scheduled for him to come on the 27th, unless we get another once in a lifetime storm.
So we're gonna give him until the 4th is what I'm hearing?
Well,
No.
the recess is gonna be 28th.
28th.
That's
Right.
not one.
They already indicated they're coming on the 27th.
I mean, act of God.
I don't see anything happening between now and then. Otherwise, the news would be just going nuts, you know?
Understood. All right,
Yeah.
well,
I mean, should something happen, we'll cross that bridge when we get there.
we're back up here.
They've said that they're going to come get you absolutely on the 27th. I don't know what time, but on that
I'll
day.
confirm with them that we approached and then submit the order and triple check today that that is still the confirmed date, because obviously we've had ones in the past where we confirmed too late and they had to move it. So I'm going to triple check today.
And he'll let you know.
I'll talk to.
Okay.
Thank you, Judge.
We'll talk some more. Mr.
Sir, you were charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you 3 days in jail with credit for the 2 days that you've done. You need to understand that this charge will go on your record. It's going to be there for the rest of your life. From now on, you are facing a minimum of 30 days in jail. No more proverbial slaps on the wrist. Do you understand?
Yes.
If you get pulled over, first thing an officer does is they look up your criminal history. If they see prior DWIs and they come up to you and say, smell alcohol, it's probably not going to go well. So from now forth, I would never, even if you had a sip of alcohol, get into a car. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, you can never take this off. Do you understand? This is what you want to do.
Yes.
How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
Guilty.
I will find you guilty. I want to send you to the agreement. Let me make one more thing clear, Mr. Espinoza. There is a $3,000 surcharge on this type of case. You pick up a DWI second, it's a $6,000 surcharge on your case that you can probably end up paying. I will waive it now, but understand, if you continue to put other people's lives in danger, it's not going to go well for you.
Muy bien.
Good luck, sir.
Buena suerte, señor.
Thank you.
Can we approach on something? I'd like you to hear probable cause and something.
Absolutely.
You have it pulled up?
Oh, yes, sir.
Okay.
So it's for Klaba. Okay. On January 15th at approximately 6 p.m., officers initiated a reverse prostitution investigation. Undercover officers saw a defendant parked near where she was standing. Defendant rolled down his driver's side window. Officers approached the defendant and had a conversation sexual in nature. Defendant agreed to engage in sexual intercourse with the officer in exchange for $100. Defendant and officer arranged to meet at a motel. Defendant started driving in the direction of the motel. Defendant was then stopped and identified by marked units. During this, officers located a loaded firearm behind the front passenger seat.
During the search incident, sorry.
So it would have been yeah. My argument is that the possession of the gun was not while he was engaged in this alleged criminal activity.
And we would understand where he's coming from, Your Honor. However, he did have the loaded firearm behind the front passenger seat, and this was a search incident to arrest. So that's where we would be at.
We have the unusual circumstance here of my client is an aircraft mechanic. He works over at IAH. As a result of the gun case, not the solicitation case, the gun case, he lost his job. He can get it back because he's a member of the union. But the gun case is the only problem because he was charged with a gun. He lost his job. Now, I assume we're going to be able to work out the solicitation case.
I mean, I'm sure would probably work out in conjunction as well, you know?
What began as a simple delay turns into a battle of law, weather, and human patience. Then the focus shifts from icy skies to a heated debate over a loaded gun and a secret deal. As the judge weighs every word, one question lingers. Where does guilt truly begin?
I mean, it's,
So, but in the meantime, he can't work. So.
let me read the statute. Hold on.
That one will have to finish ours. Oh, what if he's one of the
I tried to replace my plumbing, but I forgot to shut off the water. It's been all you gotta do is glue stuff.
So I'm looking at 46.02. Unlawful carrying of a weapon. A person commits an offense if the person, one, intentionally, knowingly, or recklessly carries on or about his or her person a handgun at the time of the offense. So is this at the time of the offense? Right? I guess there lies the question.
He was proceeding to the motel where the incident, that they agreed to would occur. So during the process.
So because, I mean, the offense is committed when? When the actually agreement took place.
Requires the way the charge reads, it requires, the offense is complete at the time that an agreement is
Is
allegedly
reached.
made. So
The agreement is made at the time, allegedly, when they're stopped. They had the wherewithal, if they wanted to, arrest him at that time, where subject to arrest at that time, they could have made the charge, so to speak, right? But they decided to wait.
Well, Your Honor, if I may, the statute reads they had honor about his person while committing criminal activity, and the firearm was in the vehicle while the offer was being made. It was just on the way to the hotel or the motel is when they stopped him and search incident to arrest for that solicitation. That's when they found the firearm. But the firearm was on or about the defendant's person while he was engaged in the offer for the solicitation.
And also, if I may, Judge, I would also say it would make sense for safety procedures for them to make the arrest while he was on the way to the motel so that they could have followed him and it wasn't just that undercover officer there at the scene and making the arrest.
No, I don't know, because they could have arrested him at the time, right on the spot. I don't know why they would try to bolster the case, I guess, by saying that there's more evidence of guilt by actually going to the motel. I mean, theoretically, they could have arrested at the time that the agreement is made, right? It's a contract.
Judge, I think we would just stick to the way the statute is worded is while engaged and the firearm was there. And they could have arrested him earlier, but as Mackenzie knows, they do that routinely for safety purposes as well as perhaps as you mentioned, they could have done it for further evidence as well, further investigation.
Prostitution cases I've seen is they arrest right on the spot, right then and there. They don't wait. I mean, the offense occurs right then and there.
And the offense did occur and while the defendant was in the vehicle, that's when the offense occurred. He was in the vehicle when they made that agreement and the firearm was in the vehicle. They found it right after they followed him to the motel. It was in the same transaction.
the offense was
I can
complete.
I agree with you. I'll find no problem. Okay. So you're charged with assault, bodily injury, you're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you 28 days in jail with credit for the 28 days that you've already done. Is this how you understand it?
Yes, sir.
Excuse me. This charge will go on your record. It's going to be there for the rest of your life. You need to understand that from now on, you're facing a minimum of 90 days in jail for cases like this that you pick up.
Yeah.
You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you can never change this.
Yes, sir.
What you want to do?
Yes, sir.
How do you plead to your offense? How do you?
Guilty.
I'm going to find you guilty. I will follow it. Good luck to you, sir. Thank you, Josh. CC.
The courtroom opens in confusion and quiet frustration. A defense attorney pleads for mercy, not for his client's crime, but for time itself. A winter storm, fierce and unforgiving, has grounded planes across Mississippi, delaying a defendant's extradition. Act of God, the judge calls it, half in jest, but fully aware of the gravity. The courtroom hums with weary acceptance. Justice will have to wait. Yet beneath the routine paperwork and legal phrasing, a deeper tension begins to stir. Mr. Kim, the defense attorney, fights for a man whose freedom is measured in days. He doesn't control the weather, Kim insists, challenging the quiet machinery of law that rarely pauses for human circumstance. But the judge reminds him rules are rules, and probation comes with signatures that bind tighter than chains. A pre-signed waiver, an agreement with the fine print, leaves no room for leniency. Even in acts of mercy, the law remains cold. Then the courtroom shifts. Another defendant, Espinosa, stands trembling as the charge of driving while intoxicated echoes across the room. His sentence seems small, 3 days, but the judge's warning cuts deep. From now on, a minimum of 30 days. No more slaps on the wrist. Espinosa's quiet yes sir sounds less like acceptance and more like surrender. Behind him, the weight of a lifetime record settles in silence. The law has spoken, and redemption will come with scars. But the storm outside is nothing compared to what comes next inside. The scene pivots sharply to a new case, darker, more dangerous, an undercover sting. a defendant accused of solicitation, caught in a trap woven from whispers and hidden wires. Yet what shocks the room isn't the deal he struck, but what officers found inside his car, a loaded firearm waiting behind the seat. The defense argues fiercely the gun wasn't part of the crime. The judge listens, eyes narrowed. When does the offense truly begin, she asks. The courtroom holds its breath. Was the crime completed when the offer was made, or when the journey towards sin began? Each attorney builds their case on timing, intent, and inches of legality. But beneath it all lies the oldest struggle of justice, the line between guilt and circumstance. The prosecutor counters coldly. He had the gun while committing the act. The logic is simple, the danger undeniable. And with that, the judge delivers her verdict, firm, clear, and absolute. No problem found. The law once again prevails over emotion. By the end, one more defendant faces judgment for assault. The same rhythm repeats. Rights waived, guilt accepted, hope reduced to routine. The courtroom empties, leaving behind echoes of confessions, conditions, and consequences. And as the final gavel falls, a quiet truth lingers in the air. In this room, storms may delay justice, but they never stop it.